Jim Hinton, thank you for talking to the students at the University of Waterloo. With your experience of intellectual property, I think this is going to be very helpful to them. Can you please begin by describing what you do in your work as an intellectual property lawyer?
Yes. So what I do is, generally speaking, I help people protect their ideas. On a day-to-day basis, I do a lot of things like negotiating with the government to get patent rights, trademarks, industrial designs, and other mechanisms. So helping people with their ideas, their business, and providing legal services.
Okay. Interesting work and valuable.
Yes.
You say that innovators face a commercialization dilemma. Can you describe what that is?
Yeah, so it's specifically new innovators, people who haven't done it before, haven't navigated the IP system before. They don't know what to do, and the problem comes down to public disclosures. The issue really is when you don't have any resources, you want to get some money. So you want to go to investors, you want to go and talk to them. But before you do that, you want to protect your IP, your intellectual property, your ideas, your invention. So you need to talk to a legal service provider maybe and pay them to get this IP protection. But you don't have any money. So it's sort of this paradox of sorts where you have to protect your IP before you disclose it, talk to investors, put it online, but you don't have the resources to do that protection. So you have to, that's the dilemma. What do you do? And it can be tough.
Yes, absolutely. You've worked with many technology entrepreneurs. What are the common mistakes that you see being made on intellectual property?
Okay, generally speaking, I think that the big problems come in to do with IP strategy. So intellectual property strategy, this is a multidisciplinary thing. You have the business person, so they know where the money's going to be made, they have an idea of what they're going to do, and they have the technology person, and then you have the legal sphere. So all three of these collide when you're developing your intellectual property strategy. You have to have input from the legal expert, the business expert, and the technology experts to determine what you need to do, how you need to protect your idea, how many resources you want to spend on them. And then, and it's a strategic approach. All those three people, or it could be one person if it's a startup, come together and then develop the coherent plan of what you're going to do, how you're going to protect your ideas, and going from there. Very specifically, and it goes back to that other issue is public disclosure. A new innovator, somebody who's never navigated the system before, they can go out and they can publish something or put something on their website and not know that they're essentially giving away certain rights. For example, in Europe, you can lose rights by not filing before you publicly disclose. So sometimes clients will come to us and they'll say, "Oh yeah, I've come up with this great idea," and it'll turn out that they have it they've already put it all on their website, or they sold it already. So they may have foregone rights in places like Europe. But luckily in Canada and the U.S. and other jurisdictions, there's a 1-year grace period from public disclosure, so you can publicly disclose first and then file without losing patent rights in some cases. So there's that grace period, but you still have to meet that 1 year. So you have to be aware of giving away your invention or your opportunity for patenting.
Makes sense.
Mm-hmm.
So investors are said to want clean ownership of IP. Can you explain what that is and why it's important?
Yes. So investors certainly want clean ownership of IP because they want to usually have an investment stake in a company that holds the IP. So in situations where there's an inventor who may be a student or somebody that's coming in, does a little bit of work, and then leaves, you want to ensure that that person has assigned their IP ownership rights to the company. All of the best case scenario, or in usual cases, you have all of the IP rights assigned to the company, and then the investor knows that they're getting what they're getting, and there's nobody else there with lingering rights. And then it will be clean in a sense.
Okay, that makes sense. At what stage in the development of their idea and business should a technology entrepreneur start to think about intellectual property?
I think the thought process needs to start early and sort of be often. When it comes to things like patents, really you want to talk to somebody when you get that eureka moment, when you're developing something and you're saying, hey, that's neat. That's an unexpected thing, or I've never seen something like that before. So that's really the hallmark of the patent. That's when you go to the patent lawyer and say, listen, I've got a great idea. It's never been done before. This is something that's very interesting. And then in terms of a trademark, you want to consider trademark protection whenever you're going to launch your brand. Whenever you come up with a name, you don't want to pick a name that somebody else is using in a crowded space. You want to have your brand identity clean as well. So you want to think of it early and often. That's when you want to think about it, and then you can consult with a professional about it as well.
Okay. Thank you. That's clear. When should an entrepreneur seek legal advice on intellectual property, and what are the cost implications? When should they come and speak to a lawyer? Yeah, so the thing is, like most other areas that entrepreneurs are going to get into, there's going to be things that they don't know. So they need to recognize that and then go to the people that do know that. So that's really when you need to go to the IP professional or something like that. You don't know what you're doing, and then you get that help. In terms of costs, patent applications can range from $5,000 to $15,000 or more, depending on the complexity and depending on the amount of work that needs to be done, as well as a few $1,000s per jurisdiction to apply. So that's for the application. Prosecution is about maybe $5,000 to $10,000, and that happens maybe 3 to 5 years out, as well as other government fees. And then in terms of enforcement, it could be anywhere from $500,000 or more. So it can be quite expensive. It is a business decision. You're saying that our business needs to protect this asset. We want to do it. Just like any other property rights, you want to put up a fence, you know that you have something valuable inside that fence. So it's a business decision for that. In terms of trademarks, another big area for IP, the cost is about $1,000 to $2,000 to registration. Relatively inexpensive, but you want to do a search and other things before that as well. So the trademark is another form of IP, but it can be just as valuable. Okay. Thank you. How do you determine whether action is necessary to pursue some form of intellectual property protection?
Yeah, so the protection arises in a lot of different ways, and like I said before, I think it's really important to have the business person, the technology person, the person who knows what is going to be valuable in the innovation, as well as the legal experts to sort of know what protection you're going to be able to get. And then you can do things like for a patent, do a patentability assessment and to see what you could actually get a patent for ultimately, to see whether that's going to be valuable enough. And so it's this IP strategy thing. You can also, in lieu of getting a patent, you can keep things confidential. Trade secrets are a good example. So you can keep things secret and use mechanisms to keep things secret. So there's alternatives, and you weigh what you're going to do. Sometimes it may be in your best interest to forego any intellectual property protection and give everything away, and because it's just going to be too much money to invest in the protection, so you just give it away and get yourself to market first. That's a strategy as well. So it's those three groups of people that would come together and develop that strategy together.
Okay, thank you. A range of options exist for an entrepreneur, and you've talked about patents and trademarks. Can you maybe describe a little bit more about when each of these is appropriate? Mm-hmm.
Okay, so the big one that we do a lot with is patents. So that protects an innovation, an idea, an invention, and it protects. You have to think about: can it be easily copied? Can it be reverse engineered? Can somebody else come up with it right away? So the patent is sort of this exclusive right to use what you're adding to the state of the art. So it has to be new, has to be inventive, and it has to be useful. And the sort of corollary to that is what I was talking about, trade secrets or confidential information. So when you come up with a great idea, it's in your mind, right? And you don't have to share it. So you can keep it in your mind, and you can maybe share it with one other person. So the two of you can keep it a secret, and we can keep our secret together. So as long as that secret is kept, then it has value, because the information has value. So the patent entices that information out and then gives it to other people for those exclusive rights. And then in terms of other ones, there's trademarks, so that's going to protect your brand. And you have common law trademarks and registered trademarks, and they both have varying levels of value. You seek trademark registration. When you seek trademark registration, it gives you registration presumed across the country. So it's certainly can be more valuable than the common law trademark. Another thing too is industrial design, and I think that is becoming more and more important. It protects the ornamental features, just like this chair, of something. So it's not functional like a patent would be or an invention would be, but it's the ornamental features, what it looks like, and sort of your unique design. And they can be less expensive than getting a patent protection, and they can be just as valuable. You see a lot of litigation and a lot of big companies using them as well. And then another one that is sort of similar to industrial design is copyright. So for literary and artistic works, music, any video you would have on YouTube would be well covered as well. And copyright's a little bit easier. As soon as you fix it in form, in a lot of cases, it will be protected, and then you can get a registration later. But it's a lot easier to protect because you have copyright just by fixing it down.
That makes sense. You've said that Kickstarter and similar tools can cause IP problems. Can you talk about why and how the entrepreneur should approach this?
Yeah. So Kickstarter is a crowdsourcing program. And the difference between getting traditional investors is you're basically saying, this is my idea, invest in my idea. Traditionally, when you go to an investor, you say, I want you to sign a non-disclosure agreement. I'm going to tell you my idea as long as you promise not to use it, because you don't want them stealing that idea. So when you share something on Kickstarter, it goes, as soon as you launch, everybody can see what you're doing. If it can be easily reverse engineered, they can get to market before you can, because they may have more resources. The reason you're going to Kickstarter is because you don't have the investors, and you want to use the public to invest, hundreds of people, thousands of people. So less scrupulous people would be able to just look at your idea, see it, take it, and then start making it, beat you to the market. They can rip off your name. They can rip off your trademark. They can rip you off entirely. Start selling directly to your customers if it's something. It could be done like that, and then you're sort of left late. And these things, Kickstarter it's international. Everybody has access to it. In other countries, somebody in another country can start doing it. So if you want to, even if you do get your intellectual property rights protected and registered, you still have to enforce it. So these guys are banking on you never making it to the stage where you have enough money to enforce it. So if you want to go to certain countries to enforce your intellectual property rights, because this is where these guys are doing it, you'd have to pay hundreds of thousands of dollars in some cases. So they beat you to the punch, and they smother you before you have a chance to get very far. So it can be dangerous. So you really want to consider what you're doing and why you're doing and what you're putting on these Kickstarter pages. Sounds like good advice. Kickstarter it could be dangerous. Yeah, I've had a number of clients do very well on Kickstarter. It's and have a lot of investment. So it's certainly an avenue for getting funding. And I think the big thing with Kickstarter is you don't give up any equity. So you get to keep a lot of your company and still get a lot of money back. Yeah. Okay. So if an entrepreneur is going to enter into the patent process, what do they need to understand about that? What are they letting themselves in for, and what are they going to need to do? Well, specifically for patents, I think the first thing that you want to do is in most cases, you want to do a search. And what would I be getting a patent for? is it going to be worth it? If 100 other people are doing the same thing, and what you could get a patent for is very small, you have to think about strategically whether that's going to be valuable. So you do a search and you get comfortable with what you could ultimately claim, and then you move into the application drafting stage. And that is the bulk of the costs. The more that you do, the more that you describe your invention, the more that you go into detail of what you're actually doing, the more valuable the patent can become. You're the entrepreneur, the technology person with the startup company is going to be the expert on the technology. So the more that they can disclose and talk about their invention, the easier it will be to get the patent. And then ultimately you draft it, you file it, and then it sits with the government for a period of time, and then you prosecute it. There are mechanisms to have your patent internationally. You still have to file it ultimately in every jurisdiction you want protection, but there's easier ways of getting patents in an international strategy as well. But the big thing to think about when going international is you want to think about why you're getting a patent there. A lot of people say, I want a patent everywhere. I want to stop everybody from doing it, but you have to have some sort of plan of enforcing it in that country or licensing it in that country or keeping a key competitor from producing it in that country. Like I said, it's a business decision. It's a strategy. And then you get your patent allowed in each country, and it would register, and then 20 years from filing it would expire. And before expiry, you can license it, you can sell it, you can let it go abandoned if your business has changed direction, you can give it away. It's not, everybody says, oh, the patent is only as good as the enforcement. It's going to cost me $100,000, $500,000 to enforce it, but there's other values. Just think of any time that you have seen a patent and said, oh yeah, this is what these guys are doing. Maybe we shouldn't do that. And you never hear about those people. So it has value, that sort of chilling effect of saying, okay, maybe we shouldn't go into this area because these people have a protection for it. So you don't even know some of the value that you could get out of it.
Okay, makes sense. If an entrepreneur believes that their IP rights have been infringed, what are the steps they should take? They presumably should come to a lawyer? Or? Yeah.
Well, that's probably the best thing to do, is to talk about what the strategy is, where you want to go. There's all sorts of ways to stopping an infringer if that's your goal. You can send a simple cease and desist letter, and that's relatively cheap, maybe $1,000. Send with the letter, say stop doing it. We have this patent, and maybe they'll stop. Who knows? And then it can escalate into full-blown litigation, which can lead into millions of dollars and trying to get damages. So you really want to be aware of what point, how far you want to take this, like any sort of legal dispute, how far you want to go. There are other easier mechanisms. If somebody's, for example, infringing your copyright, there's takedown notices and doing things like that are less expensive. And a lot of third-party websites such as eBay, if somebody's selling something that infringes your patent on there, then they may take that down. So maybe that's a choke point. You can take it off. So there's other alternatives that are going to be less expensive, but it really depends on the scenario that you're in and how much you want to push back to fight the infringer.
Thank you. This has been very useful. I just have one final question for you, Jim, which is, what would you consider to be the most valuable advice that you could give a technology entrepreneur today? If you had one piece of advice to give them, what would that be? Yeah,
I think the big thing is to think strategically about intellectual property. It's a tough area. It's tough to get your head around. But if you can bring the multidisciplinary team, your technology person, your legal person, and the business person together and develop the strategy, update it, and keep it going, then you're going to be successful, and then you can focus on the real thing, making money and succeeding.
Okay. Thank you very much for taking the time to do this today, Jim. Clearly, your knowledge on intellectual property is going to be valuable to entrepreneurs, and yes. I look forward to talking to you more about it in the future.
Yes, good. Thank you.